All right, welcome back, y'all. This is going to be the final lecture in Unit 1. This is Unit 1E, the right to publish, and we'll talk about two cases. The Seattle Times versus Reinhardt in 1984, and Smith v. the Daily Mail Publishing Company in 1979. Okay, the first case is Seattle Times v. Reinhardt in 1984. The decision was unanimous 9-0, affirming the lower court decision. And Justice Powell delivers the opinion. So, the question here is, do parties to a civil litigation have a First Amendment right to disseminate, in advance of the trial, information gleaned through the pre-trial discovery process? And the context here is that this guy Reinhardt runs a sort of cult in Washington state. The Seattle Times and the Walla Walla Union Bulletin are reporting about Reinhardt and his group for a decade or so. Reinhardt and some of his followers sue these two newspapers for defamation and asked for $14 million. They say basically that the newspapers scared off potential converts and potential donors, right? Reinhardt is deposed by the courts in the civil trial and refuses to provide his financial documents or donation documents or membership lists, and says that he has First Amendment rights. The newspaper filed a suit asking that Reinhardt be compelled to provide those documents. Reinhardt still refuses, claiming his First Amendment rights of speech and religion. The lower court ordered the documents to be produced, but ordered a gag on any of the information related to financial disclosure and membership for the newspaper. So the newspaper cannot publish anything that they learn in the discovery period. So the Supreme Court picks up this case and basically rules that first, Reinhardt does have to provide the documents, right? According to Rules 26 through 37 of the Federal Rules of Civil Procedure. And if he does not, he can be held in contempt of court and put in jail or fined. However, the newspapers do not have the right to publish this information gained in the discovery process because it would hinder the operations of the court. Furthermore, the news would never have gained access to this information without the court having compelled the testimony and the information. So the news does not have right to this information unless they can get it in some other way than through the pre-trial process, unless they can get, someone to tell them about it or provide documents, but they cannot use any information they learned in the pre-trial documents. Pre-trial depositions are not a part of trials, right, by a jury system, and they are not open to the public. So the news does not have this right to this information either. The information can only be published if it is gained through means other than the discovery process. Okay, so Reinhardt does have to provide the documentation, but the news corporations cannot publish it because the only way they gained access was through force of the court. All right, case 2, Smith v. Daily Mail Publishing Company in 1979. The vote is unanimous, 8-0, affirming the lower court ruling, and Chief Justice Berger delivers the majority opinion. In 1979, a 15-year-old is shot by a 14-year-old and killed at a junior high school in St. Albans, West Virginia. Two newspapers immediately arrive on the scene and discover the attacker's name and what happened. One newspaper, the Daily Mail, did not publish the name of the attacker, while the Gazette did publish the name of the attacker. West Virginia had a law stating that you cannot publish the name and identity of a minor, anyone under 18 years old, unless you have permission from the courts. The newspapers were both indicted by a grand jury for having broken the West Virginia law, stating that a paper cannot publish the name of a minor. The newspapers appealed, and the West Virginia Supreme Court claimed that the law was unconstitutional according to the First and 14th Amendments. West Virginia takes it to the Supreme Court and says that it does have a right to enforce such a law because, quote, the significance of the state's interest in protecting the identity of juveniles. However, the court rules that if the information is obtained lawfully, as it was here, the state cannot punish its publication except when necessary to further an interest more substantial than is present here. So the West Virginia law was unconstitutional. It cannot hold newspapers to account for this sort of behavior because the newspaper just did normal reporting, and they have a right to report it. All right, that's the end of section 1. Section 2, I will get up ASAP. I'm hoping by the end of next week, which will be around the 24th, and we will be discussing religious freedom. So y'all have an amazing day. Thanks for sticking with me through Unit 1, and good luck on the test, or the paper, excuse me.